Today, we'll go over the practice of real estate and disclosures, which covers 25% of the real estate exam. So yeah, I would review this if I were you. And I did, because I was you. I passed my California real estate exam in April of 2025. And yeah, I studied. I studied a lot. And this is because I had a job lined up that required my real estate license, and I was not about to miss that opportunity. I had a lot at stake, so I made a lot of study resources. And while there are a ton of great resources out there, I couldn't find anything that actually reviewed the subjects that I wanted, how I wanted. I literally made PowerPoints, recordings, all of these things as study tools for myself. I want to see visual material or read along with some of these definitions. I want to hear the information. So I got crafty and made these videos. Thanks again for watching, liking, subscribing, supporting, learning, growing. And now let's get back to studying, shall we? Let's go ahead and get started with the largest section of the exam. Practice of real estate and disclosures. This includes specialty areas on the California exam. Again, 25% of the licensing exam will be related to these topics. Let's start with trust account management. Trust funds, also known as escrow funds, are money or items of value belonging to others that licensees receive and manage for specific purposes in real estate transactions. Real estate escrow accounts hold money on behalf of others, including earnest money deposits, rental security deposits, and any other funds being held in trust. Real estate licensees must deposit trust funds into a brokerage trust fund bank account or with a neutral escrow account managed by an escrow company. The funds must be deposited within the time frame specified in the purchase agreement, which is usually within 3 days of offer acceptance. The account in which trust funds are deposited must be separate from the broker's general operating account. A nominal amount of brokerage funds may be deposited in the trust account in order to cover banking fees, but that's it. Mishandled trust funds can result in the suspension or even the revocation of a licensee's real estate license. 2 huge no-nos: commingling and conversion are 2 primary ways licensees can go wrong. Commingling. Commingling. When trust, aka escrow funds, are mixed with personal or brokerage firm funds. Your money should not flirt with the brokerage money. Conversion is using trust funds for anything other than their intended purpose. If I convert your earnest money deposit to help me cover my sushi lunch, that is possibly going to get my license suspended or even revoked. Trust funds must be handled in a specific manner according to the established legal procedures and standards. These are established in California by California law and the California Real Estate Commissioner. Trust accounts are set up to separate trust funds from non-trust funds. Non-trust funds, again, can be deposited in this account, but only to cover sufficient banking fees. All other deposits must be trust funds. Trust fund accounts are insured for up to $250,000 by the FDIC. That's $250,000 by the FDIC. Trust accounts provide additional security for trust funds in case of circumstances such as the broker's death or the account being frozen, or if the broker or licensee is caught in litigation. Trust funds in a trust account belong to the party who submitted them until they're dispersed. Mishandled trust funds, again, result in either suspension or revocation of a licensee's real estate license. Swimming along. Moving right along into fair housing laws. Fair housing laws are designed to protect citizens from discrimination. States cannot make laws that remove rights that federal laws grant to citizens, though they can pass more restrictive laws or add additional classes to those protected by federal law. Civil rights and fair housing laws have evolved over time. Significant court cases that you should know involving civil rights start all the way back in 1866. The Civil Rights Act of 1866 prohibits discrimination based on race or color. There are no exemptions under this law. It is never legal to discriminate on the basis of race or color. This act protects the rights of U.S. citizens to buy, sell, convey, inherit, and possess property. The act, however, did fail to have an immediate impact on discrimination because no agency was assigned to enforce it. In the 1890s, Plessy versus Ferguson set a fair housing precedence, which led to what would be known as the separate but equal doctrine. In Buchanan versus Warley, 1915, a city ordinance prohibiting Black people from living on a block where existing residents were white banned William Warley, an African American, from moving to the block where he wanted to live in Louisville, Kentucky. So he backed out of the sale. The case eventually ended up in the U.S. Supreme Court, which determined that the Louisville Ordinance violated the Civil Rights Act of 1866 by denying to the colored race the enjoyment of all civil rights. In the 1950s, Brown versus the Board of Education took place, which is a famous turning point for civil rights law in the United States. It eliminated the idea that separate but equal was fair and just under the law. In Jones versus Alfred H. Mayer Co., the court determined that even private homeowners could not discriminate in housing sales and rentals. The Fair Housing Act was passed as Title VIII of the Civil Rights Act of 1968. This act prohibits housing discrimination based on race, color, national origin, and religion. The Housing and Community Development Act, which passed in the 1970s, added sex to the list of protected classes. This gave protection to women, who are often subject to sexual harassment from landlords and sellers when attempting to obtain housing. The Fair Housing Amendments Act of 1988 extended fair housing protections to cover familial status and disability. It also provided remedies to victims of housing discrimination. It required that owners make reasonable accommodations to property rules, policies, and practices in order to provide persons with disabilities appropriate access. Federal laws outline 7 protected classes: race, color, religion, sex, disability, familial status, and national origin. Some courts have upheld that discrimination based on sexual identity is protected under the prohibition of discrimination based on sex. Race and color are 2 protected classes, but they are different in meaning. Race has to do with ancestry, color has to do with the color of one's skin. National origin is a protected class that has to do with a person's geographic origins. National origin can be specific, for example, people from Mexico, or more general, for example, people from the Middle East. Familial status refers to anyone who has a child under 18 living with them, including pregnant women and those in the process of adopting. The following activities are considered covered transactions related to anti-discrimination laws: selling or renting housing or residential lots, providing real estate brokerage services, performing appraisals or providing financing, advertising housing for sale or rent. It's illegal to perform any of the following acts if the action is based on discriminatory factors and involves a protected class: refusing to sell or rent a house, refusing to show an available house or a unit to a prospective buyer or tenant, offer different terms, conditions, or privileges when selling or renting a house, indicate a preference or limitation when advertising a home for sale or rent, coerce, threaten, intimidate, or interfere with a person's housing rights. There are some exemptions or exceptions to federal fair housing laws. The Housing for Older Persons Act of 1955 provided exemptions for housing specifically designed for seniors. The exception allows those who live in senior developments in which at least 80% of the units are occupied by at least one person who is 55 or older to choose residence on the basis of age. They may not discriminate on the basis of any other protected class. Owner-occupied buildings with no more than 4 units may be exempt. This is commonly known as the Mrs. Murphy exemption. This exemption is disallowed if the owner uses discriminatory advertising or if a licensee becomes involved in the transaction in any way. Roommates who share a rental unit may indicate a gender preference when selecting a roommate, including in advertisements, as long as the situation involves shared common areas such as the bathroom and kitchen. Single-family housing that's sold or rented without a broker's assistance, if the owner doesn't own more than 3 properties at one time, is exempt. No real estate licensee may be involved and no discriminatory advertising is permitted. Housing that's operated by religious organizations or private clubs that limit occupancy to members are exempt, provided that membership rules do not discriminate. Discrimination based on race is never permitted under any circumstances. The Office of Fair Housing and Equal Opportunity, OFHEO, which is part of the U.S. Department of Housing and Urban Development, HUD, enforces federal fair housing laws. Aggrieved parties, including licensees, can file fair housing complaints through the OFHEO for as long as 1 year following the time the alleged discrimination occurred. Licensees may not file on behalf of any other aggrieved party. A fair housing specialist will review the complaint, determine if a violation exists, and if so, assist the victim in filing an official complaint. Suspected fair housing violations may be investigated by a civil rights organization using a paired testing system to determine if discrimination has taken place. If found guilty of federal fair housing violations, licensees may face license suspension or revocation, lawsuits, and payment of compensatory damages. Title II of the Americans with Disabilities Act, ADA, of 1990 prohibits protected class-based discrimination in the delivery of commercial and public programs, services, and activities. The law is administered and enforced by HUD. Disability or handicap is a physical or mental impairment that substantially limits one or more of a person's major life activities. The ADA requires business owners to make a reasonable effort to resolve usage barriers for people with disabilities. For example, lifts or ramps should be in place for wheelchair accessibility. Housing providers may inquire as to the nature of a non-apparent disability if an applicant requests ADA-related accommodations or services. A service animal is not a pet. The ADA requires a landlord to make reasonable accommodations for service animals and for all disabled persons, not only the visually impaired who use a service animal. The Equal Credit Opportunity Act, ECOA of 1974 requires lenders to give consumers equal access to credit. The act prohibits discrimination based on race, color, religion, national origin, sex, marital status, or age with respect to granting credit, and requires lenders to respond to all loan applications within 30 days, giving reasons for any application rejections. Redlining. Redlining is an illegal, discriminatory practice by lenders or insurance companies that refuse to lend or that limit business within specific geographic areas based on the demographics of the area rather than on the creditworthiness of the specific borrower. Figuratively drawing a red line around an area to indicate unwillingness to lend mortgage funds for or insure homes in that area. In another twist, the practice of charging non-white borrowers higher fees or interest rates may be referred to as reverse redlining. Blockbusting. Blockbusting is also known as panic selling, and it is the act of inducing property sales by threatening that the changing demographics or the entry of a minority resident will decrease home values. Licensees who engage in this behavior for their own profit are guilty of violating fair housing laws. Steering. Steering is the act of guiding prospective buyers or tenants away from a location based on their membership in a protected class. Licensees who engage in this practice are guilty of a fair housing violation. Buyers and tenants are free to select properties based on demographics, as long as licensees don't use demographics as a basis for showing properties. California's Fair Employment and Housing Act, FEHA, FEHA, extends protections to several classes in addition to the 7 federally protected classes. Protected classes under California housing law are race, color, religion, national origin, ancestry, disability, mental and physical, sex, gender, gender identity, gender expression, sexual orientation, source of income, marital status, familial status, genetic information, age. In addition, citizenship, primary language, and immigration status are protected under the Unruh Civil Rights Act, which applies to housing accommodations. Ranging from advertising and selection processes to land use practices and restrictive covenants. FEHA doesn't include owner-occupied single-family homes, renting a portion of the house to one person, as long as the owner doesn't post discriminatory advertising. When a rental includes shared living space, advertisements may specify that the rental is available only to renters of one sex. FEHA prohibits discrimination and harassment in a variety of housing practices. The Unruh Civil Rights Act protects specific classifications of people from discrimination by all business establishments, which includes most housing accommodations. While the Unruh Civil Rights Act specifically lists sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, marital status, or sexual orientation as protected classes, the California Supreme Court has held that protections under the Unruh Act are not necessarily restricted to these characteristics. The Act is meant to cover all arbitrary and intentional discrimination by a business establishment committed on the basis of any personal characteristics similar to those of protected classes. Housing complaints in California may be resolved through the Department of Fair Employment and Housing's formal complaint process. This is the DFEH's complaint process. The formal process begins with filing a complaint, then proceeds to an investigation. If a violation is discovered, the process continues until resolution is found, which may be through litigation by the DFEH. The Fair Lending Notice discloses the 2 types of discrimination that are prohibited by the Housing Financial Discrimination Act, also known as the Holden Act. The Act prohibits discrimination by lenders based on protected class of the consumer or the characteristics of a property's location, aka redlining. The truth in advertising. The Federal Trade Commission, FTC, Act protects consumers from unfair and deceptive advertising. The Act works to ensure that advertising is truthful, non-deceptive, fair, and evidence-based. An unfair ad is one that causes or is likely to cause substantial consumer harm, which is not outweighed by benefits to the consumer. A deceptive ad is one that contains statements or omits material information and is likely to mislead consumers who are acting reasonably. The FTC determines penalties based on the violation's severity. Penalties range from a cease and desist order, which becomes effective immediately, to corrective advertising, civil penalties, consumer and other monetary remedies, and informational remedies such as consumer notifications and disclosures. The Do Not Call Implementation Act of 2003 makes phone solicitation to numbers on the Do Not Call registry illegal, unless a prior business relationship or permission exists. The Can-Spam Act of 2003 protects consumers against unwanted email solicitations. Under the Junk Fax Prevention Act of 2005, go ahead and say that 5 times fast. Junk Fax Prevention Act, Junk Fax Prevention Act, Junk Fax Prevention Act of 2005. It's illegal to send an unsolicited commercial message via fax unless the sender has permission from the recipient or an established business relationship with the recipient. Licensees must include their licensed name, license identification number, and broker's responsible identity on all first point of contact advertising materials. First point of contact materials that fall under the California Department of Real Estate advertising requirements include business cards, brochures, advertisements, for sale signs, directional signs, and other items. Inducing or attempting to induce panic selling and advertisements is prohibited. Internet advertising must also include the required identifying information. It needs to appear on each page of a website on which licensee advertisement or information appears, and in with any electronic communication. Sources of information licensees can use for advertising rules include the DRE reference book and the broker's Policies and Procedures Manual, also known as the PPM. Misrepresentation. Misrepresentation is a false statement of a material fact. It can be intentional, unintentional, or made through lack of proper care. Negligent misrepresentation. An example of negligent misrepresentation is when a licensee makes a misstatement that the licensee should have known was false. Intentional misrepresentation includes remaining silent and misstating facts. Misrepresentation becomes fraud when it's intentional. Omission of a material fact is considered intentional misrepresentation. Puffing or puffery is unfortunately not this cute creature. It's making an exaggerated statement that is generally understood not to be statement of fact. The Lanham Act, spelled Lanham, Lanham, is a federal act that gives individuals and businesses the right to sue any competitor for making deceptive claims in its ads. Antitrust involves businesses that conspire to restrict competition or trade, resulting in diminished choices or higher prices, or both for the consumer. The Sherman Antitrust Act of 1890, the Clayton Act of 1914, and the Federal Trade Commission Act of 1914 are all federal antitrust laws that protect consumers from tie-in arrangements, group boycotting, price fixing, and market allocation. The Sherman Act's primary purpose is to prevent monopolies that could cause a restraint of trade. The Clayton Act supports the Sherman Act
by prohibiting mergers that would result in a monopoly. The Federal Trade Commission, created by the Federal Trade Commission Act, investigates antitrust violations and penalizes violators. Price fixing involves an agreement or collusion between competing brokers to fix contract terms, services, or products at a specific price or level, such as by suggesting there's a standard fee for brokerage compensation. For price fixing to occur, there must have been an agreement between competitors on pricing. Listing agreements in California have specific language informing the seller that commissions and fees are not fixed by law and are negotiable. Market allocation involves an agreement between brokers to divide up the market and then refrain from competing for business. Tie-in arrangements include providing a service dependent on the customer obtaining or not obtaining another service from a specific provider. Group boycotting is an agreement between two or more parties who conspire to not do business with a particular person or company. Basing your decision to do business with a vendor on your own experience or knowledge of the vendor's quality is fine, but agreeing among competitors to not use a specific vendor is illegal group boycotting. A per se antitrust violation is one in which the competing firms agree to violate antitrust laws. A per se violation means the authorities don't need to make any additional inquiries about the violation to impose penalties. The fact that collusion existed is enough. Penalties for antitrust violations may be as much as $1 million and 10 years in prison. For corporations, penalties may be as much as $100 million. Under certain circumstances, penalties may be increased to a fine equaling twice the perpetrator's gain or the victim's loss. Brokerage firms found guilty of violations may be subject to court-ordered supervision for up to 10 years. The Cartwright Act. This is California's antitrust law. It establishes specific actions as being antitrust violations and also permits private parties to pursue litigation against those who have committed antitrust violations. Record-keeping requirements. The DRE has the authority to conduct routine audits of brokers, brokerages, trust accounts, and other transaction records. Section 10148 of the California Business and Professions Code requires that brokers retain records pertaining to real estate transactions for 3 years. This includes listing agreements, deposit receipts, canceled checks, and other documents related to real estate activities that require a license. Licensees must give to signing properties a copy of any agreement a licensee prepares. That includes listing agreements, purchase agreements, property management agreements, contract addenda, and receipts for deposit. Deficiencies in trust fund handling procedures discovered during the course of an audit may result in disciplinary action for the broker and responsible licensees. Brokers who keep a trust account may maintain records using a columnar, paper-based system or a computerized accounting system. The chosen method of record keeping must be in line with generally accepted accounting principles. Record keeping for trust fund bank accounts must use, at minimum, a journal, a cash ledger, and a beneficiary ledger. What the heck are those? The trust account journal is a chronological record of all activity in the trust account. A separate beneficiary ledger must be maintained for each beneficiary of trust funds held in the trust account. Each beneficiary ledger must show the beneficiary name, property address, transaction dates, check number amounts, ending balances, reference numbers for deposits or receipts, and any other pertinent information for each transaction. A separate cash ledger is used to record deposits from and disbursements to the broker. Trust fund bank account records should be reconciled monthly. The purpose of reconciliation is to balance the trust account and ensure that all trust funds have been properly recorded in the journals and ledgers. Moving right along to agency supervision. Brokers must supervise the business and license-related activities of the brokerage as a whole and of each associated licensee and employee. California regulations require brokers to oversee the following activities: transactions requiring a real estate license, contracts, agreements, and any document that affects the rights or obligations of a party to the transaction, maintenance of transaction-related records and documents, trust fund handling, advertising for real estate services, compliance with federal and state laws prohibiting discrimination, reports for associated licensee activities requiring a license. Brokerage firms should create and implement a comprehensive PPM to help prevent violations. A PPM that covers best practices and guidelines and standards by which firm members perform their respective functions can help a broker prove supervision requirements are met, as well as avoid vicarious liability risk. If a lawsuit or disciplinary action is brought against one of the firm's associated licensees or employees, the firm's broker may be held liable for the misconduct through the concept of vicarious liability, which refers to a situation in which one party is held responsible for another party's actions or omissions. Most real estate licensees are independent contractors based on IRS rules. In order to maintain the independent contractor status of these licensees, brokers must provide supervision at the level required by the Real Estate Commission, but may not require independent contractors to work set hours, work at a specific location, or attend staff or training meetings. Independent contractors are paid based on sales, not on the time they spend at the job. So you're not licensed. What are some permitted activities of unlicensed sales assistants? Unlicensed assistants cannot perform activities that require a license. They may not host open houses, show houses, negotiate deals, or solicit real estate clients. However, they can place signs on a property, distribute marketing materials, provide factual information about a property, schedule appointments, prepare marketing or advertising materials for broker review, draft and assemble documents, and they can accept trust funds on behalf of the broker. DRE, jurisdiction and disciplinary actions. The California DRE sets and enforces real estate licensing laws and regulations in the state. The real estate commissioner is appointed by the governor to act as chief executive officer for the DRE. The DRE has a 10-member advisory commission. The commission's purpose is to develop policy recommendations and provide them to the commissioner for approval. Advisory commission members are appointed by the commissioner. 6 members are real estate brokers. 4 members are unlicensed consumers. The purpose of real estate laws and regulations is to protect the public through license requirements and DRE oversight of California licensees and real estate activities. When a consumer files a complaint with the California DRE, DRE will determine if it has jurisdiction over the matter and will decide whether the complaint is related to the violation of a real estate law. If so, DRE will investigate. If DRE initiates an investigation and finds merit in a complaint, an informal hearing will be held by the commissioner, often followed by a formal hearing conducted in front of a judge. Licensees who are found guilty of violating real estate law put their licenses in jeopardy. DRE disciplinary actions include the following: license restriction. Licensees may perform all real estate activities, but is on a probationary status. License suspension. The licensee must cease all real estate activities for a period of time determined by the DRE. License revocation. The license is revoked and may not be activated. The former licensee may apply for a new license after 1 year, though the DRE may choose not to grant the license. Additional disciplinary actions may include assigned education, fines, and orders to return documents or property belonging to others. Licensing and continuing education requirements and procedures. Real estate services include helping others buy, sell, lease, exchange, finance, or option real property. Licensure is required when performing real estate services for others for compensation. California has 2 real estate licenses, broker and salesperson. A salesperson must work under a broker's supervision and license. A broker can choose to be independent, to run a brokerage, or to work as a salesperson with the title of broker associate under the supervision of another broker. Exemption to licensing laws apply, and certain people may conduct real estate activities without a license. These entities, people, are individuals performing real estate activities on their own behalf, apartment resident managers or their employees, corporate officers or general partners who receive no special compensation for corporation or partnership real estate activities, persons holding a duly executed power of attorney from the property owner, attorneys at law performing legal services for a client, receivers, trustees in bankruptcy, or persons acting under court order, trustees selling real property under a deed of trust, persons associated with or employees of banks, credit unions, insurance companies, loan institutions, pension savings and loans associations, and trust companies. Licensed securities brokers and dealers performing real estate activities in that capacity. Nonprofit organizations, cemetery authorities, escrow agents, residential mortgage lenders or servicers acting under that license. Individuals who, in a calendar year, make collections of 10 or fewer payments or amounts of $40,000 or less on loans secured by real property. Organizations for which the primary business is not real estate services and separate compensation for the real estate activity is not received. That's a long list. A corporation that offers real estate services as part of its service mix must employ a broker officer who is designated to supervise the corporation's licensees. A prepaid rental listing service provides listings of residential property available to rent to prospective tenants for a fee, but is not involved in negotiating lease or rental agreements. Both salesperson and broker applicants must be at least 18. California does not offer reciprocity with other states. Broker applicants must have at least 2 years of experience as licensed real estate salespersons in California. Licenses are renewed every 4 years and require 45 hours of approved continuing education coursework. These 45 hours must be completed prior to renewal. There's one exception. Licensees who are at least 70 and whose licenses have been in good standing for at least 30 consecutive years are exempt from the CE requirements. They must still submit a renewal application, though, and pay a fee. Good news, Grandpa. Your real estate license that you're still using, good job. You still have to pay a fee. CE hours may include topics on agency, ethics, fair housing, implicit bias, risk management, and trust fund handling. Licensees must also complete CE hours on consumer protection topics and potentially on consumer service. Licensees must keep their licenses active. What? I know, crazy. If a license is not renewed on time, the license may not practice real estate until it's been renewed or a new license is issued. If a license has been lapsed for less than 2 years, the licensee may renew by completing continuing education requirements and pay a renewal fee and a late fee. If a license has been lapsed for longer than 2 years, the licensee must reapply for a new license, repeating the entire license application process. If a broker's license lapses, all associated licensees' licenses are placed on inactive status until the broker renews or the licensee's transfer to another broker. To transfer a license to a new broker, the current broker must notify California DRE and return the license to the associate. The licensee must then complete a transfer request through the DRE system. The new employment broker certifies the transfer and assigns the licensee to the new brokerage. Licensees may obtain a mortgage loan originator, MLO, endorsement by completing the required coursework and paying a fee. The endorsement is valid for 1 year. An MLO endorsement allows a licensee to negotiate, make, and service loans for residential real property of 1 to 4 units. Licensees must complete 8 hours of CE each year to renew the MLO endorsement. Licensees go through the Nationwide Mortgage Licensing System and Registry, also known as the NMLS&R, to obtain the MLO endorsement. California Real Estate Recovery Fund. The recovery count is a fund that compensates consumers who have been awarded a judgment against a licensee but have been unable to collect. Show me that paper. The account is funded by license fees. Payments from the recovery account are limited to $50,000 per transaction and $250,000 per licensee, regardless of the number of victims from the transaction. Licensees must repay the recovery account for monies paid out on their behalf, plus interest. Until the account is repaid, the licensee's license is suspended. General ethics. The National Association of Realtors, NAR, Code of Ethics, CO, and Standards of Practice is widely accepted as a guideline for real estate professionals who serve the public. The CO has been referred to in court cases to help inform court decisions involving real estate professionals. The duty of acting in good faith means you put your client's interests first, even ahead of your own. When facing an ethical decision, your client's interests trump your own interests. Show respect for other licensees in your words and actions. Performing due diligence for a licensee means practicing reasonable skill and care, such as by investigating issues that might affect a transaction. The duty of providing reasonable skill and care means licensees offer clients the benefit of their expertise and knowledge, but don't offer advice in areas in which they are not trained, such as law or appraisals. Licensees are obligated to know, understand, and follow all laws and regulations related to real estate. Licensees have a duty to recognize issues with a property that clients may not understand, and to educate clients so they can make informed decisions. Licensees who act outside the scope of their license by offering legal advice are guilty of the unauthorized practice of law. Drafting contract language is outside a real estate licensee's scope of expertise. Licensees may fill in the blanks on contract forms that were created and approved by an attorney. Misrepresentation can be purposeful or inadvertent, but it's always unethical. Licensees have a duty to be informed and up to date on the properties they list, as well as about general industry issues. Self-dealing is a type of misrepresentation where a personal interest in a transaction isn't disclosed. If you have a personal interest in a property or are related to someone with an interest, this fact must be disclosed to clients. Technology. Real estate licensees risk exposure to litigation when using technology such as websites, social networking sites, and email to promote themselves and their listings. A brokerage's computer system must keep client data secure. If the computer system is compromised, client data is compromised. Firewalls, antivirus, and anti-malware software, encryption, and keeping systems up to date are all good methods of maintaining a secure computer system. Licensees who use technology, including brokerage systems or their own personal computer, must also use care to avoid inadvertent security breaches. Having a solid policies and procedures manual, the PPM, that discusses the use of technologies for marketing and communication can help licensees avoid litigation. Advertising rules apply online. Illegal cloning involves copying a legitimate website to scam unsuspecting users. Scraping is a software technique that harvests listing photos, addresses, and descriptions from publicly available data. An online rental scam occurs when a con artist uses publicly available property information to fraudulently rent property. To reduce risk from online rental scam artists, don't post information in the MLS about when your clients will be away, and monitor internet activity on your listings. When posting information about your clients' properties on social media, avoid disparaging the property or allowing comments by others, or providing information that compromises your client's interests or safety. When posting on social media, keep your own safety and that of your clients in mind. Limit the amount of personal information you post. Never post pictures of a client's possessions that could encourage thieves. Never post a description that indicates a good opportunity for criminals, such as being alone at an open house. The MLS enables brokers to create and access a pool of listing information that can be shared by all MLS members. Brokers must pay a fee to be members. These fees cannot exceed the MLS's operating costs. Brokerages may choose one or more MLS systems in which they participate. Generally, the broker selects the MLS that carries the greatest number of listings in their market area. Brokers who list property on the MLS must include their terms of cooperation and compensation. The MLS also contains expired, withdrawn, pending, and sold listing information that members may use. The MLS provides broad market exposure for listings. Sellers must give permission for a licensee to use the MLS to market a listing. Agents should use caution not to compromise a seller's safety or valuables in MLS postings. MLS members generally aren't allowed to self-promote in their listing data. Information posted must be accurate and up-to-date. Failure to update data in a timely fashion is an MLS violation and may constitute a violation of truth in advertising laws. Withholding a listing from the MLS without the client's express permission or against the client's wishes is a violation of the MLS rules. Waiving MLS participation requires a client's written approval. The waiver must be submitted to the MLS. Although participation in the MLS does carry some concerns for privacy and security for the seller, the benefits include increased marketability and potentially a higher sales price. Property management. The property manager's primary function is to produce the greatest net return for the owner while preserving or increasing the property's value. In general, property managers owe these duties to landlords: perform in accordance with the property management agreement, market the property seeking tenants to rent on terms acceptable to the landlord, account for all money and property in a timely manner, provide required budgets and reports, ensure that the property is kept in good repair. The property manager is responsible to both the building owner and tenants. For the owner, the property manager's goal is to rent units at a rate that yields the highest return, minimizing vacancy, controls operation costs, and maintains the property value. For the tenant, the property manager's goal is to provide value for rent paid and comply with fair housing and safety laws. Individuals and firms can get training and certification in property management specialization from professional organizations. Individuals can earn a certified property manager designation. Firms can receive the Accredited Management Organization certification. Types of property managers in California include resident managers who live in the buildings they manage. California law requires property with 16 or more units to have a manager living on site. This type of property manager is not required to hold a real estate license. Property managers who manage properties for owners, but are not resident managers, must hold a real estate license to perform duties such as showing and leasing units and collecting rents. Employees of the licensed broker don't need to be licensed to perform these activities. Building managers usually manage one building and work for a property manager or an owner. State law requires property managers to use credit reporting fairly. If a tenant applicant is rejected due to the credit report, the property manager must tell the tenant this and notify the tenant how to obtain a copy of the credit report. The Costa-Hawkins Act limits the impact of local rent control laws, especially for new units, single-family detached homes, and condos. It also protects vacancy decontrol for landlords. The Tenant Protection Act of 2019 is effective as of 2020. It applies statewide rent control that primarily impacts multi-unit buildings older than 15 years. Under the Tenant Protection Act, a landlord can't make annual increases to an existing tenant's rent of more than 5% plus the cost of living, and in no case more than 10%. A property management proposal documents the rights and obligations of the property manager and owner to one another. The proposal should provide information about the property manager's qualifications, the duties the property manager will perform, and the reports that the manager will provide to the owner. If both parties are amenable to the terms presented in the property management proposal, the relationship and conditions are agreed upon in a signed property management agreement. A property management agreement formalizes the agency relationship and outlines the duties and rights of each party. Property managers must provide monthly reports to owners on income and expenses of the properties they manage. Property management requires command of generally accepted accounting principles, as well as knowledge of building systems, budgeting, fair housing laws, types of leases, construction, and many other activities. Property managers must be conversant with different types of lease arrangements and lease renewal laws and know how to legally enforce lease provisions. Property managers may be responsible for both operating funds and funds belonging to others, including prepaid rent and security deposits. Operating accounts are used to pay expenses related to managing the property, such as maintenance, utilities, contractor expenses, or staff salaries. Rent is deposited into these accounts. Trust accounts, also called escrow accounts, hold funds belonging to others. Security deposits are one example of trust funds a property manager will hold. A property management plan is a tool that can assist with meeting an owner's goals and includes information about the property's intended use, condition, projected income, expenses, operational issues, and needed capital improvements. A market analysis will include a review of the demographic, geographic, and governmental environment in which a property is located. It should also include a competitive assessment. An operating budget is an annual budget that includes income and expenses related to the property operations. It informs decisions that allow maximum profitability for the property. A marketing plan includes a competitive analysis, building analysis, goal statement, marketing budget, timeline, and measurement. A rent roll contains a tenant list, tenant rents, unit types, and lease termination dates. Commercial, industrial, and income properties. Investors have a lot of options when it comes to real estate purchases. Some investments are active, such as buying a residential rental, while others are passive and more similar to buying stocks and bonds. Condos, single-family detached homes, and plexes, multifamily attached homes, such as a duplex, are examples of residential properties. Residential properties are popular with investors because they're always in demand. Several sectors exist within the category of commercial investment property. Properties in the retail category are developments or areas composed primarily of retail stores. These include strip malls, neighborhood centers, regional, super regional, and mega malls, and factory outlets. Leisure properties include golf courses, movie theaters, restaurants, and motels. A mixed-use property is one that combines zoning classifications, usually commercial, retail, and residential. Types of industrial properties include warehouses, heavy and light manufacturing, and distribution centers. Heavy manufacturing property is usually found further from residential areas. Examples include automobile plants and the steel industry. Light manufacturing property involves assembly and construction of consumer products such as apparel, home accessories, furniture. Warehouses are storage and distribution centers for products. Those who invest in unimproved land see value in the ability to build on a blank canvas rather than use existing improvements. Investors often specialize in either commercial or residential. Residential properties involve greater leveraging options as they're relatively liquid, and their terms and risks are easier to understand. Commercial real estate investments are generally more complex. They require experience to evaluate the investment and the ability to take a greater risk. In commercial properties, usable square footage is the area that's actually occupied by a tenant. Rentable square footage is the usable square footage plus the tenant's share of hallways, lobbies, and other space. Trade fixtures, chattel, are items that belong to the business owner and are used to conduct business, such as an oven in a restaurant. They may be removed by the tenant when the tenant leaves, provided their removal does not cause damage to the leased property. Pizza Hut can take their pizza oven, as long as it doesn't mess up the property. The Americans with Disabilities Act, ADA, and California building codes require commercial buildings to be accessible to disabled individuals, such as those who use wheelchairs. Newly constructed buildings must abide by all regulations in the ADA. Older buildings must make reasonable efforts to remove barriers and make service in public areas accessible for people with disabilities. Risk, liquidity, and leverage are all factors to consider when investing in real estate. Risk: the likelihood that the investment will lose money for the investor. Generally, the greater the potential reward, the greater the risk. Liquidity refers to the ease in which an investment can be converted to cash. A savings account is relatively liquid, since the owner can withdraw funds anytime. When money is tied up in real estate, it's not available and is therefore illiquid. Leverage refers to an investor's ability to use a small amount of cash and a loan to own property that will then produce income. For example, if an investor puts 10% down on a property worth $350,000, the investor paid $35,000. Over the next 6 years, that property produces an annual income for the investor. It also appreciates 20%. The investor has leveraged the $35,000 cash to earn on the entire $350,000 initial value of the property, not just on the $35,000 invested. Equity buildup is a paper gain in the equity in a property over the amount initially contributed toward the down payment. Pyramiding uses one investment property to finance another. This is accomplished through refinance or sale and a new purchase. 3 passive ways to invest in real estate include real estate syndicates, real estate investment trusts, and real estate mortgage investment conduits. Each has different benefits and rules of how they operate and how they or the investors are taxed. A real estate syndicate, a group of organized investors who jointly participate in real estate investments. One member fills the role of managing the property, while the majority of the members are passive investors who provide the funds for the project. A real estate investment trust, or REIT. REIT is a trust or company in which investors can own shares and benefit from the trust's real estate investments. A mortgage right invests in real estate debt, and an equity right invests in income-producing properties. Real estate mortgage investment conduit, or a REMIC, an entity used to pool mortgage loans and issue mortgage-backed securities. Finding a niche helps licensees focus their efforts and conserve energy and resources. A niche can be based on geography, demographics, property type, property value, or client type. An individual's unique characteristics, experience, and background are useful when deciding on a niche. Teams in a real estate brokerage function as firms within a firm, but are still supervised by the managing broker. Joining a team has advantages and disadvantages. Each team member specializes in certain aspects of real estate service. This can allow you to shine, but can also prevent you from learning about other aspects of the work. Each team member shares in the proceeds of the team. This could earn you money sooner than working on your own, but you'll earn less on each transaction. The experience and knowledge gained in the real estate field can translate to other careers. What are those? Oh, I'll tell you. Broker. Requires proper licensing as well as management ability, business acumen, leadership skills, and people management skills. Developer. Constructs improvements on land. Requires the ability to see opportunity, raise capital, and execute plans. Investor. Puts up funds to subdivide and develop land or purchase rental property. Realizes return when the properties sell or receives income from rentals. Requires deep pockets. Requires risk-taking and problem-solving abilities. Mortgage broker. Acts on behalf of buyers to find best interest rate and terms for a loan. Requires attention to detail, the ability to research, people skills, and the ability to clearly explain financial concepts. Real estate educator. Educates licensees and pre-licensees on laws, rules, and practices. Requires the ability to convey complex information in layperson's terms. Property manager. Manages properties for others. Requires multitasking, record keeping, bookkeeping, and reporting skills, as well as tenant relation skills. Appraiser. Determines the value of real property, commercial and residential. Requires licensing or certification per state requirements, and the ability to value real property according to established standards, and to prepare reports. Real estate attorney. Can legally broker deals and answer questions for real estate licensees. Requires a law degree. Real estate counselor. Assists clients in making informed real estate decisions. Requires real estate expertise and the ability to evaluate properties for their potential. Transfer Disclosure Statement, or the TDS. California sellers of residential property must provide buyers with a copy of the real estate TDS as soon as practicable and before transfer of the title. Residential home sales of dwellings of 1 to 4 units, including manufactured homes, require disclosures using the TDS. If the buyer hasn't received the TDS prior to making an offer, the standard residential purchase agreement gives the seller 7 days after offer acceptance to deliver required disclosures, including the TDS, unless the transfer is exempt. The TDS details the seller's knowledge of the physical condition of the property, as well as the items that affect the property. TDS disclosures include age and condition of the structure and systems, easements and fences, flood, drainage, and soil issues, zoning violations and non-permitted work, HOA obligations and deed restrictions, citations or lawsuits affecting the property, noise or nuisance problems, location of the property in a known earthquake zone. Only the seller may complete the seller's portion of the TDS. Additional sheets may be attached to the form if needed to fully explain the property's condition. The seller, buyer, and their agents sign the TDS. Buyers have 3 days after the seller delivers the TDS to rescind the purchase agreement based on the information about the property condition. The Agent Visual Inspection Disclosure, or AVID, and Seller Property Questionnaire, SPQ, forms can be attached to the TDS. The AVID form is a California Association of Realtors form completed by agents to document their required visual inspection of the property. The SPQ is a California Association of Realtors form that can be used by sellers to ensure that they consider all aspects of the property that may require disclosure to prospective buyers. An agent's responsibility regarding the TDS is to inform the seller regarding the legal responsibility to complete it properly, make certain it is completed thoroughly, perform a visual inspection, disclose any issues, and deliver the TDS promptly. Nature Hazard Disclosure Statements. The NHDS, or NHD, is required for most residential transactions involving property of 1 to 4 units. For other property types, the same disclosure requirements apply, but they don't have to be provided on the NHD form. Sellers may complete the form themselves using information available from state and federal agencies, or may use a third-party provider known as a natural hazard disclosure company to complete the form. The NHD discloses to buyers if the property lies within any of 6 natural hazard zones: flood hazard zone, dam failure inundation area, high fire hazard area, wildland fire area, earthquake fault zone, seismic hazard zone. The NHD should be provided to prospective buyers at the first opportunity. The residential purchase agreement requires that disclosures be provided to the buyer within 7 days after offer acceptance. Buyers who have made an offer before receiving the NHD may rescind without penalty after receiving the NHD, provided they do so by the stipulated deadline. Disclosure of material facts affecting property value. Disclosure laws in California, as a result of decisions such as in the Easton versus Strasburger case, are strict. Licensees must know the appropriate disclosure requirements, provide the proper disclosure forms to buyers, and make sure those forms are correctly completed. A material fact is one that would cause a party to take action or not take action regarding a property purchase, lease, or option. Licensees have an affirmative duty to disclose all known material facts about a residential property to a buyer. Sellers have a responsibility to disclose not only the things they have actual knowledge of, but also the things that a reasonable person would be aware of or should know about. These disclosure requirements apply to residential properties of 1 to 4 units and to manufactured homes. Disclosures that are normally required when selling residential real estate don't apply to court-ordered transactions such as foreclosures, divorce settlements, probate, bankruptcy, and eminent domain cases. Licensees have a duty to visually inspect properties and investigate potential issues. This duty does not extend to hidden areas or latent issues not known to the licensee. Visual inspection should focus on red flags that would indicate a possible physical issue with the property. Anything that seems like a problem should be followed up with questions to the seller. In California, both the seller's agent and buyer's agent must investigate and inspect potential red flags on properties. This duty applies to residential property of 1 to 4 units and manufactured homes. Again, it doesn't apply to court-ordered transactions. Licensees must disclose to all parties any known adverse material facts. A licensee is required to disclose any adverse material information to potential buyers that is not already disclosed by the seller before a sales agreement is made. Disclosures should be provided to prospective buyers as soon as reasonably possible before the offer is accepted. If a seller hasn't provided proper disclosure and deceit is discovered after closing, buyers can sue the seller for breach of contract or fraud. Buyers must take legal action within 2 years of taking possession of the property. If a seller hasn't provided proper disclosure and closing hasn't yet occurred, buyers can terminate the agreement and ask for a refund of their earnest money, or ask the seller to make necessary repairs or provide credit to the buyer. Disclose according to MAAP principles. Any information that is material, adverse, and actually known about the physical condition of the property must be disclosed to potential buyers. Common signs of foundation problems include cracks in basement walls, moisture in the basement, misaligned doors and windows, cracks in the drywall, and separation around garage doors. Common roof issues to look for include discolored or curling shingles, water buildup or ice damming in gutters, damage to flashing, water damage along fascias, and cracks, holes, or rotting on soffits. Common chimney and fireplace issues include creosote buildup on the exterior of the chimney, drafts near the fireplace, a cracked or sloping hearth or firebox, and loose and crumbling bricks. Common window problems include damaged or broken glass and screens, windows that stick or won't stay open, damaged hardware, and leaking or damaged seals, often indicated by fogged window glass. Fixtures are generally items attached to the property. These items stay with the property. Personal property is removed by the seller when the home is sold. Buyers should inquire about the condition, age, and maintenance related to heating and cooling systems, electrical systems, and plumbing. Common plumbing problems include water damage on ceiling or walls, leaking or blocked drains, clogged or leaking toilets, reduced water pressure, and soggy ground around the home. Common signs of electrical issues include switches that are warm to the touch, lights that burn out quickly or dim when others are used, burnt or discolored outlets, faulty appliances, and old or damaged circuit breakers. Common heating and cooling issues include hot and cold rooms, a furnace or AC unit that won't turn on when the temperature is adjusted, or a pilot light that won't stay lit. Unpermitted work could result in partial or full disassembly of the work to inspect it, as well as possible correction or restoration to the original state if issues arise. If there appear to be any additions or alterations to the property, buyers should investigate whether permits were pulled. Missing, cracked, displaced, or otherwise damaged roof components and shingles could be a sign of wind or storm damage. Fire damage can include discoloration in the attic or around windows and doors. Flood damage can include discoloration of walls, sagging or uneven floors, and a musty odor in the home. Standing water for more than 24 hours after heavy rain may indicate drainage problems. Common wood-eating pests include termites, carpenter ants, and powder post beetles. The presence of tiny wings or mud tubes indicate termite infestation. Carpenter ants leave behind a sawdust-like material called frass. Small holes bored in wood indicates the presence of powder post beetles. A stigmatized property is one that has a negative psychological event attached to it. Disclosure of all material facts, including information about a stigmatized property, helps sellers and licensees avoid liability. In California, the seller must disclose a murder or suicide that occurred on the property within the last 3 years. It's considered a material fact, and licensees are also obligated to disclose if they have knowledge of the event. Possible hauntings are also considered stigmas that must be disclosed to prospective buyers. If the event didn't occur on the property, it doesn't need to be disclosed. Whether the descendant or a former resident had AIDS must not be disclosed, because to do so would violate fair housing laws. Homes in Melrose districts are subject to additional property taxes that may not be readily apparent to buyers. Therefore, seller disclosure is required. California law requires disclosures for specific situations, including Megan's Law. While it isn't the seller or the seller's agent's responsibility to research registered sex offenders in the area, the sales contract must include a disclosure as to the existence of a public database where this information may be obtained. Natural hazards. 6 forms of natural hazards that may impact their property are disclosed on the NHD statement. Proximity to airports. Properties near an airport or under a flight path can experience high levels of noise and vibration. Disclosures can be made with a notice of airport in vicinity, which is usually included in the NHDR if necessary. Proximity to a ranch or farm. If the property is located within 1 mile of farm or ranch land, as determined by an NHD expert, a third-party disclosure company, the NHDR must contain a statutory statement called the Notice of Right to Farm. Natural gas and other hazardous liquids pipelines. Similar to Megan's Law disclosure, this is a notice that must be included that informs the buyer that the information about the location of these pipelines is available from an internet source. If the seller or seller's agent has actual knowledge about zoning that would allow industrial use of property in the area, this must be disclosed to the buyer. Former meth lab site. This must be disclosed even after it's cleaned up. A copy of the cleanup order must be provided to the buyer. Military ordnance location. If a former military training ground exists within 1 mile of the property, this must be disclosed due to the potential for explosives. Mining operation. If the property is within 1 mile of a mine operation, the property disclosure must contain a notice of mining operation. This is usually part of the NHDR. Sellers and landlords of properties built prior to 1978 must provide the buyer with a lead-based paint disclosure, as well as an EPA pamphlet describing how to minimize the dangers of lead. Buyers have a 10-day period in which to conduct a risk assessment for lead-based paint or lead-based paint hazards. Lead poses health problems, and it may be present in paint manufactured prior to 1978. The Environmental Hazards Booklet, titled Residential Environmental Hazards Guide, a guide for homeowners, homebuyers, landlords, and tenants, describes several environmental hazards that can potentially cause a health risk and which apply to residential properties. The Environmental Hazards Booklet isn't required, but when it's provided to a buyer, The seller and agent do not need to provide further disclosures to the buyer about the hazards covered in the booklet unless there is a specific issue that affects the property. Need for inspection and obtaining verifying information. Seller disclosures are not always accurate, and sellers may not be aware of all defects with a property. A home inspection can determine the property's true condition. A home inspection uses a qualified individual to evaluate the physical condition of the home structure and systems, identify anything that needs to be repaired or replaced, document any health or safety issues that could affect residents of the home. Licensees should encourage all buyers to obtain a home inspection, even for new construction. A home inspection contingency is one of the best ways to protect the buyer's earnest money. If an inspection uncovers issues the buyer wants the seller to repair, it's the buyer's agent's responsibility to communicate those requests to the listing agent and follow up on the status of the repairs. California makes all inspection findings subject to disclosure if they are considered adverse material facts. Reports. Buyers should be advised to carefully review all reports obtained from financial inspections and investigations. Buyers should be prepared to act in their own best interests and according to contract contingencies based on the information provided. The buyer is obligated through the residential purchase agreement to give the seller copies of any investigation or inspection reports the buyer obtains for the property. The Residential Earthquake Hazards Report is a disclosure form used for sellers to notify buyers of the earthquake preparedness of a home and whether the home lies in an earthquake or seismic zone. The Residential Earthquake Hazards Report is only required for transactions where the property is a home built prior to 1960. The Residential Earthquake Hazards Report disclosure form is part of the Homeowner's Guide to Earthquake Safety, published by the California Seismic Safety Commission. Residential sellers must disclose to the buyer whether a property is in a Mello-Roos district. Disclosure must include the amount of any fees as well as the assessment's purpose. Reports the buyer should expect to order or receive include the home inspection, pest inspections, environmental conditions or hazards, and title reports. Companies that provide national hazard disclosure reports generally include information covering all statutory disclosures in the report, including Mello-Roos assessments. Servicing diverse populations. Real estate professionals are most successful when they work to understand and respect the customs and practices of other cultures. Working with colleagues from diverse backgrounds can be challenging but rewarding. Office diversity is the best way to provide services to a broad array of clients. A number of obstacles to home ownership have been identified, and these tend to have disproportionate effect on minorities. Obstacles to home ownership include younger age, lower income, denial of credit, language barriers, lack of affordable housing, and discrimination. Government loan programs, such as those run by the Federal Housing Administration and the U.S. Department of Veteran Affairs, are a critical component of introducing more homeowner opportunities for all of the underrepresented populations. Studies of home ownership and long-term residence show that these factors are tied to the development of strong, stable communities, regardless of other socioeconomic factors.
Fair housing laws require non-discriminatory treatment of tenants and homebuyers. Members of NAR are obligated to conduct real estate activities in non-discriminatory ways as provided by Article 10 of NAR Code of Ethics. Real estate trade organizations focused on promoting minority homeownership include the National Association of Real Estate Brokers, NAREB, real estate trade organization founded in 1947 as an equal opportunity and civil rights advocacy organization for African American real estate professionals, consumers, and communities in America. Its stated mission is to promote democracy in housing. The National Association of Hispanic Real Estate Professionals, NAHREP. Its mission is stated to advance sustainable Hispanic home ownership, and it describes itself as a purpose-driven organization that is propelled by a passionate combination of entrepreneurial spirit, cultural heritage, and the advocacy of its members.
The Asian Real Estate Association of America is dedicated to promoting sustainable home ownership opportunities in Asian American communities. Its membership is open to all housing and real estate professionals who support its mission.
Hey, good job!
That is a wrap on the practice of real estate and disclosures.
Thanks again for watching, liking, subscribing, supporting, learning, growing. Bye.